Chairman of the Goa State Legal Service Authority, Justice Manish, Justice Valmiki Moses, keynote speaker, Senior Advocate Ranjit Kumar, President of the High Court Bar Association, my friend and former Union Law Minister, Mr. Goan, Advocate General, Senior Advocates, my colleagues, professors in the law firm, warm welcome to this August gathering on the eve of the Law Day. Every year, we commemorate the Law Day with a keynote speech by a prominent person from the legal fraternity. This year, Law Day is on a Sunday and it is vacation time. It required courage of conviction to hold this function on a Saturday evening. Full marks to the managing committee and of course to the president of the association who took this function to a new high by inviting the former Solicitor General of India. Mr. Ranjit Kumar has chosen the topic rule of law and constitutional values. So apt for the day. Rule of law, we know, is a most celebrated concept in the history of democracy. Various nations, various jurisdictions have tried to give different meaning to this concept. It required a multi-dimensional approach. Even Aristotle tried to give a meaning to it, and he said it is reason of law. Many said it is part of natural justice. English law and English jurisprudence has become part of the basic structure of the Constitution, and we take it as a principle against arbitrariness both from the executive and the legislature.
Ranjit Kumar needs no introduction. He is an acclaimed senior advocate designated in October 2000. He was the Solicitor General of India from 7th of June 2014 to 1st of November 2017. In some of the highest traditions at the bar, he has often appeared pro bono in many deserving cases. He has successfully represented persons from various walks of life, notable amongst them Dr. Shankar Dayal Sharma, President of India, in the challenge to his election as President of India, Justice V. Ramaswamy in his impeachment proceedings right up to Parliament, Sri P.V. Narasimha Rao, former Prime Minister of India, in the Lakhubai Pathak case, that is the pickle case, and the JMM bribery case. Some of the earliest judgments that he has, some of the earliest cases that he has appeared in before a constitutional bench of 5 judges in the Supreme Court is the case pertaining to the challenge to the amendment to the Land Acquisition Act 1894, in the case which is reported as the Vakil Singh versus Union of India. He is also an amicus curiae in many cases before the Honorable Supreme Court, some of which are the matter of interlinking of rivers in India, the case of R.D. Upadhyay, dealing with under-trial prisoners in various jails, the plight of women and children, prisoners who are suffering from mental disorders. He has also been directed to head a committee of 3 advocate members to go to Bhopal and give a report as to the disbursement of compensation to the Bhopal gas victims. He was directed to visit the mosque and the Madar of Mirza Ghalib in connection with cleanliness and developments in that area. He has been requested to assist the Constitution Bench in many matters. And he is presently assisting the Honorable Supreme Court for the betterment of Lord Sri Jagannath Temple in Puri, Orissa. I request the Honorable Keynote Speaker for today, Mr. Ranjit Kumar, to kindly address the gathering.
Good evening, everybody. Justice M.S. Suna, Chairman of the Goa Legal Services Authority and Judge of this court. Justice Menezes, the Judge of the High Court of Bombay at Goa. The Advocate General, Mr. Devi Das Pangam. Mr. Koiro Pereira, the President of the Bar Association. The Office Bearers of the Bar Association and the Office Bearers of the Legal Services Authority. The Office Bearers of the Legal Services Authority, Senior Advocates, former Law Minister Mr. Ramakant Khalam, colleagues and members of the bar, the professors and principals of the law colleges, the administrators, the students, ladies and gentlemen. You will pardon me if I am making a speech from a prepared speech and not making it extempore, because there are a lot of quotations which I will be reading. So please forgive me for that. Rule of law and constitutional values. I will preface it by just saying this, that our constitutional values are very much ingrained. If you look at the preamble of our constitution, word by word, and you will find, and I will give definitions to them later on in this evening, that each of those words will bring to you the values which our constitution requires of us and which are ingrained in our constitution. With that preface, the rule of law is a political ideal that all citizens and institutions within a country, state or community are accountable to the same laws, including lawmakers and leaders. Simply stated, no one is above the law. The term rule of law is closely related to constitutionalism. It refers to a political situation, not to a specific legal rule. The rule of law is defined in the Encyclopedia Britannica as, and I quote, the mechanism, process, institution, practice, or norm that supports the equality of all citizens before the law, secures a non-arbitrary form of government, and more generally prevents the arbitrary use of power. Unquote. Use of the phrase can be traced to the 16th century Britain. In the following century, the Scottish theologian Samuel Rutherford employed it in arguing against the divine right of kings. John Locke wrote that freedom in society means being subject only to laws written by a legislature that apply to everyone, with a person being otherwise free from both governmental and private restrictions on his liberty. The rule of law was further popularized in the 19th century by the British jurist A.V. Dicey. However, the principle, if not the phrase itself, was recognized by ancient thinkers. Aristotle wrote, "It is more proper that law should govern than any one of the citizens. Upon the same principle, if it is advantageous to place the supreme power in some particular person, they should be appointed to be only guardians and the servants of the law." The rule of law implies that every person is subject to the law, including persons who are lawmakers, law enforcement officials, and honorable judges. John Locke also discussed this issue in his second treatise of the government in 1690, and I quote, "The natural liberty of a man is to be free from any superior power on earth and not to be under the will or legislative authority of man, but to have only the law of nature for his rule. The liberty of man in a society is to be under no other legislative power but that established by consent in the Commonwealth, nor under the dominion of any will or restraint of any law, but what the legislature shall enact according to the trust put in it. Freedom then is not what Robert Filmer tells us, a liberty for everyone to do what he lists, to live as he pleases, and not to be tied by any laws, unquote. John Locke goes on to say, but freedom of men under government is to have a standing rule, to live by, common to every one of that society, and made by the legislative power erected in it. A liberty to follow my own will in all things, where the rules prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man, as freedom of nature is to be under no other restraint but the law of nature, unquote. Although credit for popularizing the expression rule of law in modern times is usually given to Dicey, development of the legal concept can be traced through history to many ancient civilizations, including Greece, India, Mesopotamia, and Rome. The idea of rule of law is often regarded as a modern iteration of the ideas of ancient Greek philosophers who argued that the best form of government was the rule by the best men. Plato advocated a benevolent monarchy ruled by an idealized philosopher king who was above the law. Plato nevertheless hoped that the best men would be good at respecting established laws, explaining that, and I quote, where the law is subject to some other authority and has none of its own, the collapse of the state, in my view, is not far off. But if the law is the master of the government and the government is its slave, then the situation is full of promise and men enjoy all the blessings that the gods shower on a state, unquote. More than Plato attempted to do, Aristotle flatly opposed letting the highest officials wield power beyond guarding and serving the laws. The Roman statesman Cicero is often cited as saying, roughly, within quote, we are all servants of the laws in order to be free, unquote. For us in India, the longest constitutional text in the history of the world has governed the country since 1950. Our constitution for us is intended to limit the opportunity for governmental discretion, and the judiciary uses judicial review to uphold the constitution, especially the fundamental rights. Although some people have criticized the Indian judiciary for its judicial activism, others believe such actions are needed to safeguard the rule of law based on the constitution, as well as to preserve judicial independence, an important part of the basic structure doctrine. The Secretary General of the United Nations in 2019 defines the rule of law as, and I quote, a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to the laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with the international human rights norms and standards. It requires, as well, measures to ensure adherence to the principle of supremacy of the law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency, unquote. The Council of the International Bar Association passed a resolution in the year 2009 endorsing a substantive definition of the rule of law, and I quote, "An independent, impartial judiciary, the presumption of innocence, the right to fair and public trial without undue delay, a rational and proportionate approach to punishment, a strong and independent legal profession, strict protection of confidential communication between lawyers and clients, equality of all before the law. These are all fundamental principles of the rule of law. Accordingly, arbitrary arrests, secret trials, indefinite detention without trial, cruel or degrading treatment or punishment, intimidation or corruption in the electoral process are all unacceptable. The rule of law is the foundation of a civilized society. It establishes a transparent process, accessible and equal to all. It ensures adherence to the principles that both liberate and protect. The International Bar Association calls upon all countries to respect these fundamental principles. It also calls upon its members to speak out in support of the rule of law within their respective communities." Unquote. The constitutional values flow from the preamble of the Indian Constitution, which reads thus, and I am reminding all of you here, I am sure you have read it many times, what it reads like. "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." In our Constituent Assembly, this the 26th day of November 1949, do hereby adopt, enact, and give ourselves this Constitution. 74 years to this day, one day short, if I may say. What does the preamble and its well thought out concepts, which are just placed like sovereignty, socialist, secular, democratic, republic, justice, liberty, equality, fraternity, signify? And I take each one of them and I present to you. Sovereignty. It declares India a sovereign, socialist, secular, democratic republic. Being sovereign means having complete political freedom and being the supreme authority of itself. It implies that India is internally all-powerful and externally free. It is free to determine for itself without any external interference, either by any country or individual, and nobody is there within to challenge its authority. This feature of the sovereignty gives us dignity of existence as a nation in the international community. Though the Constitution does not specify where the sovereign authority lies, but a mention of, and I quote, "We the people of India," unquote, in the preamble clearly indicates that sovereignty rests with the people of India. This means that the constitutional authorities and organs of government derive their power only from the people. Socialist. We are aware that social and economic inequalities have been inherent in the Indian traditional society, which is why socialism has been made a constitutional value aimed at promoting social change and transformation to end all forms of inequalities. Our Constitution directs the governments and the people to ensure a planned and coordinated social development in all fields. It directs to prevent concentration of wealth and power in a few hands, The Constitution has specific provisions that deal with inequalities in fundamental rights and the directive principles of state policy, Part 3 and Part 4. Secular. We are all pleased when anyone says that India is home to almost all major religions in the world. In the context of this plurality, secularism is seen as a great constitutional value. Secularism implies that our country is not guided by any one religion or any religious considerations. The Indian state is not against religions. It allows all its citizens to profess, preach, and practice any religion they follow. At the same time, it ensures that the state does not have any religion of its own. Constitution strictly prohibits any discrimination on the ground of religion. Democratic. The preamble reflects democracy as a value. As a form of government, it derives its authority from the will of the people. The people elect the rulers of the country, and the elected representatives remain accountable to the people. The people of India then elect them to be a part of the government at different levels by a system of universal adult franchise, popularly known as one man, one vote. Democracy contributes to stability, continuous progress in the society, and it secures peaceful political change. It allows dissent and encourages tolerance. And more importantly, it is based on the principles of rule of law, inalienable rights of citizens, independence of judiciary, free and fair elections, and freedom of the press. Republic. India is not only a democratic nation, but it is also a republic. The most important symbol of being a republic is the office of the head of the state, that is the president, who is elected and who is not selected on the basis of heredity, as is found in a system with monarchy. The value strengthens and substantiates democracy, where every citizen of India is equally eligible to be elected as the head of the state. Political equality is the message of this provision. Justice. Justice ensures that freedom of one does not become the tyranny of the other. The justice to be truly meaningful needs sharing of power, compassion towards underprivileged, and empathy towards the disadvantaged. An education of rights and duties becomes important to ensure to fight justice. Liberty. Liberty of thought and action is a fundamental value embedded in our Constitution. It is the basis for creativity and exploration of new ideas and experiments that can advance social progress. Respecting the rights of others to liberty of thought and action are hallmarks of a civilized society. Ensuring that this liberty of thought and action is not used to belittle or diminish the beliefs and status of others is what constitutes a decent society. Democracy creates opportunity to pursue one's chosen ends as well as respect others' rights to do so. In a diverse country like India, exercising freedom with responsibility is a must for ensuring peace in the nation. Equality. Equality is another value enshrined in the Constitution. Freedom and justice remain mere words if equality is not ensured. It implies freedom from exploitation and ensuring to provide opportunities for individuals' development, irrespective of the background, gender, cultural or socio-economic identity and status. Fraternity. Fraternity is at the heart of the school, society and the nation. Social solidarity is a vital part of a society that has place for the aspirations of all members of the society. Understanding the importance of fraternity or solidarity and the knowledge that we are all belong to a large community, a nation, and the globe is also to discover our innate humanity. It is only if we recognize our interdependence when we empower to help build a peaceful nation and a world. The citizens need to internalize the principles of equality, justice, and liberty to promote fraternity among all, regardless of religious beliefs, regional and local diversity. As the Constitution encompasses the values for living in harmony and with self and one's natural and social environment, it provides the baseline in working out the framework of values to be nurtured in its students. If values like truthfulness, sense of responsibility, trustworthiness, loyalty, love, peace, respect for others are nurtured in us right from the beginning of the school, the efforts will go a long way to enable students to abide by the Constitution and contribute to larger health of the society and nation at large. In fact, promoting values at the school or societal level begins with the individual in relation to the community, larger society, nation, and the world. The dignity of the individual. Promotion of fraternity is essential to realize the dignity of the individual. It is essential to secure the dignity of every individual, without which democracy cannot function. It ensures equal participation of every individual in all the processes of democratic governance. Apart from constitutional values as enshrined in the preamble, as explained hereinabove, these constitutional values can be shortly put as constitutional principles, constitutional identity, constitutional morality, constitutional objectivity, constitutional goals, constitutional trust, constitutional governance, constitutional culture, and constitutional ethos. Therefore, I have tried to amplify the above values by referring to in detail to each of the concepts in the preamble. As described by the Supreme Court in the practice of sati in the case of Navtesh Singh Johar, the search for constitutional values is a complex quest. The quest becomes even more complex when the constitution is transformational. A transformational constitution is aspirational and therefore futuristic and endeavors to transform the society from its parent state in accordance with the constitutional prescription. The identity of the Constitution of India as a secular state is also a transformational prescription. In India, secularism has been a tool for nation building after the success of the anti-colonial movement to bring together the diverse groups in Indian society. The promise of the secular nature of the Indian state was extraordinary as an idea of nation building, and its moral appeal was certainly higher compared to the notions that are developed in our neighbors' countries. Karl Clark describes transformative constitutionalism in the context of the South African Constitution in the following words, and I quote, "By transformative constitutionalism, I mean long-term project of constitutional enactment, interpretation, and enforcement committed to transforming a country's political and social institutions and power relations in a democracy's participatory and egalitarian direction. Transformative constitutionalism connotes an enterprise introducing large-scale social change through a non-violent political process grounded in law. I have in mind a transformation vast enough to be inadequately captured by the phrase reform, but something short of different from revolution in any traditional sense of the word." According to Gary Jefferson Jacobson, constitutional identity represents a mix of aspirations and commitments expressive of a nation's past. It also evolves in ongoing political and interpretive activities occurring in courts, legislature, and other public and private domains, unquote. Gautam Bhatia discusses the transformative constitution as one that is consciously, I quote, that is consciously designed to transform not merely the existing legal and political system, but also the social and cultural structures that often undergird the law and the politics of a society, unquote. After 74 years of the commencement of the Constitution, certainly the conscious design by the framers must not be the only lens to examine India's constitutional identity. Its interpretation, enforcement, and evolution, both by the legislature and the courts, to understand its political and legal interpretation of the conscious design must be factored into to comprehend the constitutional identity as has been advocated by Clare and Jacobson. Secularism is one such constitutional identity of the Indian Constitution. In M. Nagaraj, the Constitution bench of the Supreme Court, speaking through Justice Kapadia as his lordship then was, in the context of reservation, has said, and I quote, "It is a fallacy to regard fundamental rights as a gift from the state to its citizens. Individuals possess basic human rights independently of any constitution by reason of the basic fact that they are members of the human race. These fundamental rights are important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights. It confirms their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy, to place them beyond the reach of the majorities and officials, and to establish them as legal principles to be applied by the courts. Every right has a content. Every foundational value is put in Part 3 as a fundamental right, as it has intrinsic value. The converse does not apply. A right becomes a fundamental right because it has a foundational value. Apart from the principles, one has also to see the structure of the article in which the fundamental value is incorporated. Fundamental right is a limitation on the power of the state. A constitution, and in particular that of it which protects and which entrenches fundamental rights and freedoms to which all persons in the state are to be entitled, is to be given a generous and purposive construction. Justice Kapadia goes on to say, the expression life in Article 21 does not connote merely physical or animal existence. The right to life includes the right to live with human dignity. This court has in numerous cases deduced fundamental features which are not specifically mentioned in Part 3 on the principle that certain unarticulated rights are implicit in the enumerated guarantees. For example, freedom of information has been held to be implicit in the guarantee of freedom of speech and expression. In India till recently, there was no legislation securing freedom of information. However, this court, by a liberal interpretation, deduced the right to know and right to access information on the reasoning that the concept of an open government is the direct result from the right to know, which is implicit in the right of freedom of speech and expression guaranteed under Article 19(1)(a). He further goes on to say, the important point to be noted is that the content of the right is defined by the courts. The final word on the content of the right is of this court. We may have a look at common constitutional provisions under the German law, which deals with rights such as freedom of press or religion, which are not mere values. They are justiciable and capable of interpretation. The values impose a positive duty on the state to ensure their attainment as far as practicable. The rights, liberties and freedoms of the individual are not only to be protected by the state, they should be facilitated by it. They are to be informed, overarching and informing of these rights. Overreaching and informing of these rights and values is the principle of human dignity under the German Basic Law. Similarly, secularism is the principle which is the overarching principle of several rights and values under the Indian Constitution. Therefore, axioms like secularism, democracy, reasonableness, social justice, etc. are overarching principles which provide linking factor for the principle of fundamental rights like Article 3, 14, 19 and 21. These principles are beyond the amending power of Parliament. They pervade all enacted laws and they stand at the pinnacle of the hierarchy of constitutional values. Justice Kapadia goes on to say, secularism in India has acted as a balance between socio-economic reforms which limits religious options and communal developments. The main object behind the theory of the constitutional identity is continuity, and within that continuity of identity, changes are admissible depending on the situation and the circumstances of the day. Lastly, constitutionalism is about limits and aspirations. According to Justice Brennan, interpretation of the Constitution as a written text is concerned with aspirations and fundamental principles. In his article titled Challenge to the Living Constitution by Herman Wells, the author says that the Constitution embodies aspiration to social justice, brotherhood and human dignity. It is a text which contains fundamental principles. Fidelity to the text to our fundamental principles did not limit judicial decision making. The tradition of the written constitutionalism makes it possible to apply concepts and doctrines not recoverable under the doctrine of unwritten living constitution. To conclude, as Justice Kapadia said, as observed by Chief Justice Chandrachud in Minerva Mills, the Constitution is a precious heritage and therefore you cannot destroy its identity, unquote. Justice Ganguly, as his Lordship then was in the Supreme Court, in his speech on Justice Vivian Bose, a pilgrim in the quest of constitutional values, said on the transformation of law, and I quote, "This is a great contribution to the unfolding of the important role which laws play in various aspects of our life, in the manner in which today it controls both the governmental and the daily life of an individual in its manifold dimensions. Law today can no longer be considered a relic, as something to be kept on a shelf, to be periodically brought down, dusted and admired, and then put back on the shelf again. Today law has a living presence in our daily life, and the rule of law is no longer confined within the blue blood jurisprudence of colonial vintage. Rule of law now controls the rule of life, and both have merged and given rise to a jurisprudence which is aimed to bring about an egalitarian society based on equal rights and justice. Today, law as perceived by Professor Roscoe Pound is an important tool in social engineering." He goes on to say, as a judge of the last court in the world's largest democracy, Justice Vivian Bose amply demonstrated through his various judgments that our Constitution represents charters of power granted by liberty and not charters of liberties granted by power. Justice Bose believed, for your information, Justice Bose was a judge in the mid-50s. Justice Bose believed and tried to establish that liberty is not a gift of any state to its people. On the other hand, it is the people whose unalienable right to liberty and freedom as citizens of a free republic, is assured, granted powers to the legislature and the executive for securing their liberty and not for curbing it. Whether the words in the Constitution present a printed finality, how the judges are to read the words in the Constitution. These are the questions which confronted the judges when the Supreme Court had to deal with constitutional issues. Explaining these core issues of the constitutional interpretation, Justice Vivian Bose, in the celebrated case of State of Bengal versus Anwar Ali Sarkar, rose to great heights of eloquence when in his matchless words, his Lordship unlocked the key to a salient jurisprudential technique. And I quote, "The provisions of the Constitution are not mathematical formulae which have their essence in mere form. They constitute framework of the government written for men of fundamentally differing opinions and written as much for the future as the present. They are not just dull, lifeless words, static and hidebound as in some mummified manuscript, but living flames intended to give life to a great nation and order its being, tongues of the dynamic fire potent to mold the future as well as guide the present." Unquote. Justice Vivian Bose was possibly the first judge of the Supreme Court who interpreted the width and reach of our fundamental rights through the prism of our preambular values. In his glowing dissent in 1951, the learned judge said, "Is not the sanctity of the individual recognized and emphasized again and again? Is it not our Constitution in a violent contrast to those states where the state is everything and the individual but a slave or a serf to serve the will of those who for the time being wield almost absolute power? I have no doubts on this score. I hold it, therefore, to be our duty when there is ambiguity or doubt about the construction of any clause in this chapter on fundamental rights, to resolve it in favor of the freedoms which have been so solemnly stressed. Read the magnificent sweep of the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic and to secure to all its citizens justice, liberty, equality and fraternity." Unquote. In very eloquent terms, the learned judge described the essential spirit of our constitutional liberties by saying, and I quote, "They did not bestow on the people of India a cold, lifeless, inert mass of malleable clay, but created a living organism, breathed life into it, and endowed it with purpose and vigor so that it should grow healthy and sturdily in the democratic way of life, which is the free way. In the circumstances, I prefer to decide in favor of the freedom of the subject." That was his dissent. The Constitution Bench, through Chief Justice Deepak Mishra, on governance in an elected union territory, said as under on constitutional morality, and I quote, "Constitutional morality in its strictest sense of the term implies strict and complete adherence to the constitutional principles as enshrined in various segments of the document. When a country is endowed with a constitution, there is an accompanying promise which stipulated that every member of the country, right from its citizens to the high constitutional functionaries, must idealize the constitutional fundamentals. This duty imposed by the Constitution stems from the fact that the Constitution is the indispensable foundational base that functions as the guiding force to protect and ensure that the democratic functionaries own a greater degree of responsibility towards the eloquent instrument for it. Is from this document that they derive their power and authority, and as a natural corollary, they must ensure that they cultivate and develop a spirit of constitutionalism where every action taken by them is governed by and is in strict conformity with the basic tenet of the Constitution. In this light, the observations made by Dr. Ambedkar are of great significance, and I quote, "Constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people are yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. Constitutional morality is that fulcrum which acts as an essential check upon the high functionaries and citizens alike, as experience has shown that unbridled power without any checks and balances would result in a despotic and a tyrannical situation, which is antithetical to the very idea of democracy." The following passage from Manoj Narula, another constitution bench, is quoted for throwing light on this, and I quote, "If men were angels, no government would be necessary if angels were to govern men. Neither external nor internal controls on the government would be necessary. In framing a government which is to be administered by men or over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions." Further, Justice Mishra goes on to say, "Constitutional morality acts as a check against lapses on the part of the governmental agencies and colorable activities aimed at affecting the democratic nature of our polity." In Krishnamurthy vs. Shiv Kumar, 2015, the Supreme Court explained, and I quote, "Democracy has been best defined as the government of the people, by the people, and for the people, expects prevalence of genuine orderliness, positive propriety, dedicated discipline, and sanguine sanctity of constant affirmation of the constitutional morality, which is the pillar stone of good governance." Unquote. The Constitution of India, as stated earlier, is an organic document that requires all its functionaries to observe, apply, and protect the constitutional values spelled by it. These values constitute the constitutional morality. This makes the Constitution of India a political document that organizes the governance of Indian society through specific functionaries for requisite ends in an appropriate manner. The constitutional culture stands on the fulcrum of these values. The element of trust is an imperative between constitutional functionaries so that governments can work in accordance with constitutional norms. It may be stated with definiteness that when such functionaries exercise their power under the Constitution, the sustenance of the values that ushers in the foundation of constitutional governance should remain as the principal motto. There has to be implicit institutional trust between such high functionaries. Then goes on to say about constitutional culture. Constitutional culture is inherent in the concept where words are transformed into concrete consequences. It is an interlocking system of practices, institutional arrangements, norms and habits of thought that determine what questions we ask, what arguments we credit, how we process disputes, and how we resolve those disputes. Andrew Siegel, in Constitutional Theory and Constitutional Culture in the University of Pennsylvania, is quoted to say, "The aforesaid definition of the term constitutional culture is to be perceived as a set of norms and practices that breathe life into the words of the great document. It is the conceptual normative spirit that transforms the Constitution into a dynamic document. It is the constitutional culture that constantly enables the words to keep its stride with the rapid and swift changes occurring in the society. Further, the Constitution bench in the case of R.C. Podial said this on the duty cast upon functionaries and its citizens way back in 1994, and I quote, "Mere existence of the Constitution by itself does not ensure constitutionalism or a constitutional culture. It is the political maturity and the traditions of a people that import meaning to a constitution which otherwise merely embodies political hopes and ideals." Unquote. In the case of Lakshmi Narayan, Justice Bhushan, Ashok Bhushan, as his lordship then was, speaking on behalf of the three-judge bench on the issue relating to constitutional conventions, held as under. The expression, I quote, "The expression Constitution Convention has been coined by Professor Dicey. In his introduction to the study of the law of the Constitution, in the chapter dealing with nature of conventions or constitution, Professor Dicey states, and I quote, "The conventions of the Constitution are in short rules intended to regulate the exercise of the whole of the remaining discretionary powers of the Crown, whether these powers are exercised by the King himself or by the ministry." Unquote. So said Dicey. Justice Bhushan goes on to say, Professor Dicey's statement that the convention is not a binding rule was departed with by Sir Kenneth Weir in Modern Constitution, who wrote, and I quote, "By conventions is meant a binding rule, a rule of behavior accepted as obligatory by those concerned in the working of the Constitution." Unquote. Justice Bhushan goes on to then say, Sir Ivor Jennings, in his treatise, has elaborately dealt with conventions of the Constitution. While explaining the purpose of the convention, he states, and I quote, "The short explanation of the constitutional conventions is that they provide the flesh which clothes the dry bones of the law. They make the legal constitution work. They keep in touch with the growth of ideas. A constitution does not work itself, it has to be worked by men." Unquote. Justice Bhushan thereafter proceeds to say, "The American jurisprudence also recognizes conventions, including the constitutional conventions. John Alexander Jameson, in a treatise on constitutional conventions, while explaining the constitutional convention, states, and I quote, "As its name implies, constitutional convention, not simply as having for its object the framing or amending of constitutions, but as being within rather than without the pale of the fundamental law, as ancillary and subservient and not hostile and paramount to it. The species of convention sustains an official relation to the state considered as a political organization. It is charged with a definite and not a discretionary and indeterminate function." Unquote. Leonard Sirota, in his article Towards Jurisprudence of Constitutional Conventions, defines it as, and I quote, "Those primary constitutional rules limiting the powers of the several organs of the government in a polity and governing the relations among them, which are not found in constitutional or ordinary statutes or the common law, and which reflect the constitutional theory and political values of the day." That's how Leonard Sirota says about constitutional convention. I go on to quote Justice Bhushan further. "The constitutional conventions are born and recognized in the virtue of the Constitution. The purpose and object of the constitutional convention is to ensure that the legal framework of the Constitution is operated in accordance with the constitutional values and constitutional morality. The constitutional conventions always aims to achieve higher values and objectives enshrined in the Constitution. The conventions are not static, but can change with the change in constitutional values and constitutional interpretations. No constitutional convention can be recognized or implemented which runs contrary to the express constitutional provisions or contrary to the underlying constitutional objectives and aims which the Constitution sought to achieve. Unquote. I am deeply humbled and honored to be here and to be invited to speak on the subject of my liking. You will forgive me for any lapses and thank you for hearing me with rapt attention. I am very, very honored. Thank you very much.
So we thank you for this wonderful speech, setting out constitutional values and tracing the rule of law right from Aristotle up to the present day. It has given us a lot of food for thought, especially how unarticulated rights have been treated as inherent and embedded in the guarantees which are spelled out in the Constitution. We are very grateful to you, sir, for having come here all the way. And it needs to be mentioned because I just learned that sir has even declined to accept even the payment for the tickets from us. No, and we are very grateful, sir. He has been, it's a great honor to have you here. Thank you very much. And I request, we are grateful, sir. I now request our senior judge, Honorable Mr. Justice Sona, to kindly deliver the concluding address.
My dear brother, Justice Kinesis, Mr. Ajit Kumar, Senior Advocate and former Solicitor General of India, the President and Office Bearers of the High Court Bar Association, the Advocate General, Mr. Khala, our former Union Law Minister, respected senior advocates, the academicians who are present today, the principals and the staff and the professors of law colleges, law students, respected members of the bar, and my dear friends. Greetings on the eve of Constitution Day. After such a thought-provoking and a masterly presentation by Mr. Ajit Kumar, it would be a folly to say something more. Friends, I think it was Robert Frost who once said that the world is composed of two types of people, broadly of two types of people. Those who have something to say and can't say it, and those who have nothing to say but keep on saying it. But Mr. Ajit Kumar defies both the moods. He does not belong to either of those types described by Sir Robert Frost. He had so much to say on today's subject, and he said it with such grace as well as force. It was indeed an inspiring presentation. Thank you very much, sir. This was a treat, an intellectual treat. Today, Mr. Kumar has brought to bear his vast knowledge of constitutional law, and more important, I would say, his vast experience in dealing with rule of law cases. And it is a combination of these two aspects that has gone into crafting such a wonderful presentation to all of us. His words and ideas, as you have noticed, flowed effortlessly. And when anything so sublime is presented so effortlessly, be sure that a lot of effort has gone into its preparation. Otherwise, this is not possible. Usually, I would say, it is a lifetime of preparation. Thank you, Mr. Kumar, for this illuminating evening. And I must say thank you because sometimes there is a darkness which engulfs even the most well-meaning activist, and we need to dispel it, and you have done exactly that. Thank you very much. Now, having scholars like Mr. Kumar make such scholarly presentations is one of the best tributes that the High Court Bar Association or the Goan Legal Services Authority can pay to our Constitution. Today's topic was very well chosen, as Mr. Almeida said at the outset. Rule of law may not have been specifically mentioned in our Constitution, but it is certainly the fabric on which our Constitution is written. Now coming back to Robert Frost, I must regretfully confess that I belong to the type which has nothing to say but keeps on saying. They say that wise men speak because they have something to say, and fools like me speak because they have to say something. I think the best way to know what rule of law means to us in everyday life would be to recall what happened when there was no rule of law, or when, for an unfortunate brief interregnum, the rule of law was suspended. This hallowed concept of rule of law is like the air or the oxygen that we breathe in. No sooner we have a Delhi or Bombay type of a polluted situation, we gasp to realize the importance of fresh air and constitution. As long as there is no crisis, we tend to take the oxygen that we breathe, or for that matter, the contribution of the rule of law to our lives as granted. As explained by Mr. Ranjit Kumar, the rule of law has several facets. The rule of law does not mean that any of the three organs of our government, the legislature, the executive, or the judiciary, is superior to each other. It certainly does not mean that the judiciary is superior to the legislature or the executive. Certainly not. The rule of law implies that all these branches are subservient to the law and to the Constitution. All these three branches must function within the limits set out by our Constitution. Our Constitution, which is the people's document, is what is supreme. So the supremacy of the Constitution, the supremacy of the laws, and not of men, is one of the essential facets of the rule of law. Secondly, I must say that the enduring legacy of rule of law is that no power, whether entrusted to the legislature, executive, or the judiciary, is either absolute or unlimited. All power is to be held in trust by the three branches. All power is to be exercised subject to the constraints imposed by law. Thomas Muller famously said, "Be you never so high that the law is above you." Thirdly, I would say that rule of law expects equality before the law and equal protection of the law. Special and well-defined circumstances must exist before anyone can be given a special treatment or a special protection. The application of laws must not be whimsical or arbitrary. Given the complexities of administration, some amount of discretion is inevitable. But we must endeavor to see that this discretion is minimal. Discretion must be regulated, guided, and not unfettered or untrammeled. Vesting of absolute discretion in any authority or vesting of unlimited powers in any authority is destructive of the rule of law. Fourthly, I should say that all branches must act in good faith and exercise their powers for the legitimate purposes for which the powers are entrusted to them. Constitutionally, it may not be permissible to impute bad faith to the legislature itself. Still, a law enacted by the legislature with utmost good faith may also sometimes not pass the constitutional muster. The legislature, in a sense, is a delegate of we the people. And it is in we the people the true sovereignty rests when it comes to a democratic system. So if there is a conflict between the law made by the legislature, which is to be regarded as a delegate of we the people, and the law made by the people themselves, which is the Constitution, then the former must yield and the Constitution must prevail. That is the basis of our concept of judicial review of legislation. And this is also our idea of the rule of law. Access to justice is also another important facet of the rule of law. This contemplates easy and inexpensive procedures. This contemplates a free and an independent judiciary. The concept of independence of judiciary is not primarily to afford protection to the judges. This concept is our constitution's commitment to the people. This concept is a very essential facet of the rule of law. Justice, they say, like truth, is one of the most valuable commodities that we have. But let us not go by Mark Twain's tongue-in-cheek comment, where he says that because truth is our most valuable commodity, let us economize its use. Similarly, I would say that one of the most important commandments of the rule of law should be, thou shalt not ration justice, because it is one of our most valuable commodities. Fair procedures are important to the rule of law. Therefore, the importance of natural justice. Means are as important as the ends. It is sometimes said that ends justify the means, but this overlooks the crucial detail that only just means will communicate in a just end. In gaining our rightful demands, we must avoid being guilty of wrongful deeds. Therefore, even judicial review focuses on the decision-making process rather than the decision itself. The Goa High Court Bar Association and the Goa Legal Services Authority pay a very fitting tribute to our Constitution by having such functions and discourses on some of the essential features of our Constitution, like the rule of law. I conclude by saying that we have reason to be optimistic. If some of our hopes were dupes, maybe our fears will be liars. Our fears will be liars. Say not the struggle not available. Friends, 75 years is not a very long time in history, provided we are prepared to acknowledge our mistakes and learn from them. Fortunately, we are blessed with the bedrock of traditions. We have forgotten them, but I do not believe that we have forsaken them. We have to revive them and we have to build on them. As I said earlier, functions like these and speakers like Mr. Rajiv Kumar go a long way in contributing to such a revival. Thank you very much, dear friends, and Jai Hind.
We thank Honorable Mr. Justice Goan for his concluding remarks. We all know very well that Honorable Mr. Justice Goan is a constitutional expert. Is definitely a constitutional expert, which I reiterate because I have heard him and so have many of you. Comparative constitutional law is also his forte, and we are very grateful to him for having expressed his views. I would also like to mention here that our learned speaker for today was an amicus curiae in the MC Mehta case before the Honorable Supreme Court for almost 20 years. And the Honorable Supreme Court, as a token of its appreciation, had directed the Delhi government to give him a paycheck of about 50 lakhs, which he has very generously declined. So this needs to be mentioned here that he has an enduring legacy of contributing to social causes, upholding constitutional values and the rule of law. And what he spoke today was not just from the textbook, but from the very life that he has led. And the MC Mehta case is just one case in point. I now request the Member Secretary of the Goa Legal Services Authority to kindly present a token of our appreciation to the Honorable Senior Judge, Mr. Justice Goan. That's a small token for Justice Goan. For Justice Goan, yes. And at the hands of Mr. Justice Goan, to our learned keynote speaker, Senior Advocate Mr. Rajiv Kumar. I would also request. Yes, all right. Yes. Thank you so much. Thank you so much, sir. I would now request the Advocate Gaurav Shabni to kindly propose the vote. Thanks. Member Secretary, Mrs. Vijaya Ambe, to kindly present Justice Sonak's token of appreciation. Thank you so much. I also request the Member Secretary to kindly present a small token to the President of our Bar Association, Senior Advocate, Mr. President. Thank you. I now request Advocate Gaurav Shabni to kindly propose the vote of thanks, which will be followed by the national anthem. So I would request you to all stand up for the national anthem after that. Thank you.
Dignitaries on the day, Honorable Justice Sonak, our Chief Guest and Keynote Speaker for today's evening, Sri Ranjit Kumar, Senior Advocate and former Solicitor General of India, President of the Goa High Court Bar Association, Gentleman for Goan Pereira, and all the dignitaries of the days, a very good evening. And I would like to start the vote of thanks by a quote by Melody Betty. Gratitude unlocks the fullness of life. It turns what we have into enough and more. It turns denial into acceptance, chaos to order, confusion to clarity. It can turn a meal into a feast, a house into a home, a stranger into a friend. Well, if we all had felt that Sri Ranjit Kumar was in Delhi, we had only heard the name, I'm sure today he has graced us by his presence, and he is a known figure, of course, and he is now a friend to all the youngsters who are here. Sri Ranjit Kumar ji has today taken us to a horizon of rule of law. And if we ever felt that we knew enough of rule of law, I'm sure we have learned more, and we would want to learn more. If we felt that we had any doubt on rule of law, his talk today, I'm sure, has given us clarity on rule of law. What Sir has presented to us today, as Justice Sonak said, is a compendium of his effort at the Supreme Court and his devotion to the legal profession. What he presented to us today, as said by my colleague Amira, right from the time of Aristotle to Justice Vivian Post to today, only shows his in-depth study, in-depth analysis, and the way the mind works in formulating rule of law, in formulating the arguments before the court, and his cause and his contribution to the advancement of rule of law. The way he has discussed with us the facets of what is enshrined in the preamble, I'm sure this has given us food for thought for all of us. And I'm sure, sir, your talk has convinced us to be pilgrims in the quest of constitutional values. Thank you, sir, for your talk today. Amira has said so many things about his Sri Ranjit Kumar's contribution and his presence today at the venue. I would also add to that no words of gratitude would be enough to actually convey our gratitude to Ranjit Kumarji for one simple reason. I must mention that Sri Ranjit Kumar arrived today afternoon and is flying back tonight back to Delhi for some personal commitments which he has tomorrow. He has flown in only for this brief period of 3 to 4 hours, only to be with us and to address this gathering. This just shows his devotion to the profession, his love for the bar, and the unending spirit with which he wants to contribute to the legal fraternity. And I'm sure all of us, the lawyers, students, including me, will remain forever indebted to you, sir, for your effort. Thank you so much. I would also like to thank Honorable Justice Sona for his concluding remarks and for summarizing the rule of law for us. I would also like to thank Sri Koel Pereira sir for extending the invite to Ranjit Kumar ji and ensuring that he had no right of refusal. I would also like to thank Justice Valmiki Menezes for gracing us with his presence. I would like to thank former Law Minister Sri Ramakant Pradap ji for being present amidst us today. It's always good to have you back in the High Court, sir. I would also like to thank our Advocate General for the state of Goa, Sri Devidas Pandam ji, who has always been a helping hand to the bar and has, whenever we've gone to him, there has never been a no. He is also the driving force from the state, from the bar, in organizing all this function. Thank you, sir. A big thank you to all the senior advocates, to the members of the bar who have been present today here for this function. I would also like to thank the principals of B.M. Salgaonkar College of Law, Kare College of Law, G.R. Kare College of Law, the academicians who are present here today, and all the students who have come here. And I'm sure the talk by Ranjit Kumar ji has expanded your horizon and has given you a new look to the rule of law, which will only help you to come out as better lawyers in practice. I would also like to thank Madam Vijaya Amre and the Goa Legal Services Authority for having joined hands with the Goa High Court Bar Association in organizing this commemorative event. I would also like to thank the electronic and print media for having covered this event, including telecasting this event live to all the members of the bar. A big thank you to all the invitees who are present here today, who have graced this occasion and made this event a success. I will fail in my duty if I do not thank my colleague, Advocate Amira Raza, for having compared this event and taken us seamlessly to this function. My apologies if I missed out in expressing our gratitude to any person here. Last but not the least, I would like to thank our hospitality partners, Cafe Tato, for ensuring that he gave food for thought and kept us very active through this evening. Once again, thank you, sir.